Format. King County Local Civil Rule 7B 5B requires the following format. Review this information closely. Note what it says about evidence. Deposition testimony, discovery pleadings, and documentary evidence relied upon must be quoted verbatim, or a photocopy of relevant pages must be attached to an affidavit identifying these documents. Also note the following. Specific relief, succinct statement, concise statement. In other words, be brief and to the point. Be as precise as you can in stating what you want the court to do. When you describe the facts, don't write the great American novel. State only the facts necessary for someone reading your motion to understand what the motion is about. Don't describe how you decided to file the lawsuit in the first place, or what a jerk your opponent is, or how you had to take the day off work to file the complaint. Even if all these things are true, they don't help the judge decide the motion. So, the motion should look something like this. The statement of the issue of law is tricky. This is where you have to have some understanding of the law concerning your case. We talked about this in the first videos. You have to educate yourself about the law. If you can't speak with a lawyer, the best way to do this is to go to the law library. The librarians will help you find the books and materials you need. This is also important because when you find the law, you need to identify which ones you're relying upon under the heading Legal Authority. Authority is just legalese for the law that you're relying upon. This can be statutes, rules, regulations, or cases that have previously decided the same issue that you're raising in your motion. Remember, what you are asking for must be permissible under the law. So you must find the authority that says that it is permissible, and then identify that authority for the court. Now, we need to spend a little time talking about affidavits and evidence. Evidence is a very complex subject. The important thing to remember is that every factual statement that you make in your motion must be supported by tangible evidence or sworn testimony. For example, if you mention some document, a bill, a receipt, a letter, in your motion, then you must provide a copy of it. But you don't just staple a copy of the letter to your motion. You attach it to an affidavit or a declaration. So what is an affidavit? It's a statement that you make under the penalty of perjury that something is true. Technically, an affidavit must be sworn before an officer authorized to attest to sworn testimony. A notary public is a typical example. But most often, courts rely on a declaration under a penalty of perjury. It has the same effect as an affidavit, but you don't have to make the declaration in front of a notary. A typical declaration looks like this. Pay attention to these details. I am over the age of 21. Minors cannot make declarations, so you have to state that you are old enough to do so. Personal knowledge. You have to show that you know something because you saw it or did it yourself, not because someone else told you about it. This is very important. Penalty of perjury. Take this seriously. Seattle, Washington. The reasons for this are technical. You don't have to worry about it too much. Just include it, or whatever city you're signing the declaration in. You can find sample declarations in the law library. Next, the motion must include a proposed order. Here we're looking at King County Local Rule 7B 5C. The original of each proposed order shall be submitted to the hearing judge along with any working copies. Remember, the purpose of your motion is to get an order from the court instructing someone to do what you want. Where does the actual order come from? It comes from the party who wins the motion. So you must submit the order that you want the judge to sign along with your motion. This is called a proposed order, because it is what you are proposing to the court. A proposed order will look something like this. If the judge grants your motion, she will just cross out the word proposed and sign the order. One last point. You must submit the original proposed order with the judge's working copies, and file and serve copies. Dispositive motions. Remember that King County Local Rule 7 states that all non-dispositive motions will be decided without oral argument. That refers to all motions that do not decide the entire case. So what about dispositive motions? That is, a motion that will decide the outcome of the litigation. There are two important dispositive motions that you must be aware of: summary judgment and motions for judgment on the pleadings. As the names indicate, these motions are requesting the court to enter a judgment on behalf of the moving party, and thus end the litigation in favor of that party. Summary judgment is described in Civil Rule 56, and motions for judgment on the pleadings are explained in Civil Rule 12c. The requirements for such motions are technical and somewhat complex. Either one, if granted, will end the case. They are often filed by defendants who argue that the law does not permit the kind of relief that is being sought by the plaintiff. They also differ from the regular motions that we've been talking about. Not only do they allow oral argument, but the timeline for the motions is different too. Not 6 days, but 28 days. That extra time is necessary because of the complexity of these motions. If you need additional information about these kinds of motions, or the ones that we talked about earlier, please visit your local law library.